remains in dispute.
And that report from Rita O'Reilly. I'm joined now by Brendan Howlin, Minister for Public Expenditure and Reform, and by Barrister and former Attorney General Michael McDowell. Michael McDowell, to you first. Give us a concrete example of how this could be misused or abused.
Well, the power in question, Richard, applies to any matter of public importance, and it allows the committee of the House, of either House, to investigate that and to deploy very major powers against an individual. What are matters of public importance? The Kerry Babies Tribunal was a matter of public importance. The abuse of children in the Dublin Archdiocese was a matter of public importance, which produced the Murphy Commission of Inquiry. In the past, we've had the Abbey Laura shooting, which was a query as to whether the killing of Mr. John Carty was lawful or unlawful. These are the kind of issues which have in the past been dealt with by either tribunals of inquiry, which were grossly expensive, or commissions of inquiry, which were established by me when I was Minister for Justice, which are very cheap, inexpensive, and which produce very good results, such as Judge Yvonne Murphy's report into the Dublin Archdiocese. These are the kind of issues which should, in my view, should not be determined by politicians. And what we're being offered here is a system where each House of the Oireachtas will have the separate power to decide that a matter is of general public importance. It will then be able to deploy a range of powers which involve sending investigators out, searching any office or place in the country without warrant, and any home with a warrant and the Gardaí in attendance to seize evidence. This is the kind of power which you're being asked to believe is normal in political life across Europe. It isn't. For instance, it was mentioned there on the television that the English House of Commons had an inquiry into the Murdoch phone tapping thing. They didn't make any findings. They did ask Mr. Murdoch in. He did come in. He wasn't summoned before them. And in the end, they said, we're not competent to decide where the truth of all this lies. So they appointed Lord Livesey to set up a tribunal in relation to that particular issue. Now, I have always been against excessive public expenditure on tribunals. I waived my own fees in the Moriarty Tribunal. I set up the system which has given rise to George Birmingham's report into the Grange Gorman murders, and also Judge Yvonne Murphy's inquiry into Cloyne and the Dublin Archdiocese. It isn't a matter of money. It's not a matter of cash. It's not a matter of a lawyer's clack. And if you just look at the suggestion that it's lawyers, and I noticed that your party leader said it was a lawyer's clack today. But let's be clear.
He didn't say such thing.
Senator Maurice Hayes.
He didn't say any such
Senator
thing.
Maurice Hayes, Professor John Crown, Ronan Mullen, the United Left Alliance, the Irish Council for Civil Liberties, Billy Kelleher, Mary O'Rourke. These are not lawyers. These are people who care deeply about constitutional rights.
Well, a lot of us care deeply about constitutional rights. A lot of us have been working to advance constitutional rights for 30 years. The huge majority of the Dáil, more than 80% of the Dáil, all but 3 senators, supported this legislation.
All right, but we're here tonight to help the public decide one way or another, rather than tell them who else has taken a side in this. Let's deal with the issues.
Michael got a good long run.
I know what I want to direct a question. He also got a question. The question to you is, if we take it as read that the tribunals were over-expensive and unwieldy, if we take it as read that there are matters of importance that need to be investigated, is this the only way to do it?
No, it's not. There are a variety of ways of doing it. One is the Commission of Investigations legislation brought in by Michael McDowell. He talks about the huge intrusive powers that the proposal before us now will have. They're mirrored on your legislation. The power to search and seize documents, mirrored on your legislation. And obviously a committee of investigation has to have that authority. Now, every democracy that I've looked at has this sort of power. 12 of the European Union has it enshrined in their constitution. It is the norm of an investigative power given to any functioning parliament. The problem with our parliament for the last 15 years, and most commentators have talked about it, not being robust, not holding the executive to account, not being able to investigate anything. Nobody in our society is held to account. The only mechanism we've used prior to the enactment of the legislation you brought in was the very early pre-independence legislation that unfortunately has proven to be ineffective. 14 years investigating, costing tens of millions. The legal team of one inquiry costing 50 million themselves. It's a gravy train, and Michael might say he didn't get monies from appearing before a tribunal, but many of your colleagues have been made millionaires from them. Now, he sets up then the model that he has, a welcome model, the Commission of Investigations, as something we should rely on. Let's look at, because it's not that long in existence, a very recent example of it in operation, which was the Nyberg inquiry. What did Mr. Nyberg say? He said he'd never involved himself in an inquiry. A Finnish banking expert with so many lawyers fell upon him, and he, in his recommendations in the written report, recommended more robust powers to get to the truth without having lawyers obfuscate both on individuals and on corporate entities. So he signalled that we needed a more robust investigative mechanism.
What are the safeguards? Because the public, again, would be concerned. A lot has been said in the last number of days about the safeguards or lack of them and recourse to the courts.
There is no difficulty about recourse to the courts. And, some of the commentators, including legal experts, talked about there being no specific reference to access to the courts. There is no specific reference in any section of the Constitution. We checked it, reread it today.
And what will the practice be?
The practice is that everything, unless there is a debar on it, and the only debar is in Article 45, that Michael McDowell would understand, where the courts are forbidden from having a role. In every other constitutional provision, the courts, of course, have access.
Well, is that true? Is that how you read it?
No, it's not. Hold on a second. I think you've had a good run there, Brendan.
Let's deal with that point.
Can I say, just in relation to the powers of the court, your government appointed Brian McMahon to be the independent referee on this referendum.
I'll deal with the point I made now.
Wait, just let me finish. And he has said that it is not, that in his view, he does not see that the courts will have significant, if any, powers to protect people before these tribunals. That's what he said.
What did he actually say?
That's what he said. And I just have to bring to your attention
what did he actually say,
here.
Well, can I quote you what he said?
Well, I have it here.
It's on the balance of rights and fair procedures. What the Commission says, this means that the House or Houses would have discretion as to the procedures to be applied in any given case. The balance struck in any given case may have important implications for people affected by an inquiry. It is not possible to state definitively what role, if any, the courts would have in reviewing the procedures adopted by the Houses.
Now, Richard, can we stop there? Can we stop there?
He was asked.
Sorry.
That's part of what he said.
That's all of what he said.
Brendan, let me finish the point now.
Do.
And you can develop your point after.
Thank you.
It is not possible to say what role, if any, the courts will have in protecting the citizens before these tribunals. And if it is not possible to say this is a very dangerous power. And the real problem here, Richard, stems from the decision that Brendan himself personally made. And Brendan was given a report by an all-party committee of the Oireachtas, and it said that the conduct of these tribunals was to be determined in accordance with a law which would fix that balance. And there's the paragraph there.
Just let me finish. Let me answer some of them,
substituted your...
Imbalance.
You
Imbalance, Michael.
You substituted...
We're running out of time, Michael, so I do want to get on to this.
I do want to get on to this. You've been trained to interrupt by your coaches. I'm not into that.
Michael, I do want to get on to the amendment and just see what the implications are.
It shall be... He says now, it's for each house...
Finish that point.
It's for each house...
Let him finish this point quickly and then get back to it.
I served on that committee for a year.
Yes.
I listened to the expert view of lawyers. Did you read the report that we produced?
I did.
It says there shall be a balancing, allowing the in re haughey rights to be balanced against the public interest. Page 45 of that report.
Decided by whom?
By the Oireachtas.
No, it doesn't. It says here, and can I read it to you?
In the facilitation of effective parliamentary investigation.
Brendan,
I worked on the committee.
Brendan,
I was a member of the committee.
You may have worked in the committee, but it came up...
Don't twist the wording of the commission or the recommendations of it. This is a simple mechanism to provide for Parliament the same powers as every Parliament has. There is nothing in it.
Could you explain why 8 Attorneys General have come out against it?
I don't know that.
Well, can I tell you why?
I don't know that.
Can I tell you why?
If they have grave doubts about it, doesn't it at least suggest that it's been done in haste?
No. This is a year's work of an all-party committee unanimously recommending this rebalancing.
Sorry, hold on a second. That unfortunately is...
The Oireachtas itself...
Let him finish the point,
please,
Mike.
That is not true.
Just let him finish this point, because we are running out of time.
has passed it overwhelmingly, 3 votes against it in the Shannon, a debate on the issues. We have signalled it in our manifesto, voted on by the people.
Sorry.
We have debated it up and down within the Oireachtas. And
all right, let him respond to that.
in the
Let him give you the, let him respond to that,
48
and then I'll give you
hours
the
before
last
the
word.
referendum, people emerged.
All right.
Can I get a word in now, edgeways? What the report actually suggested was the conduct of such inquiries shall be regulated by law. This is what they wanted to insert in the Constitution. Such laws shall balance the rights between the individual with the public interest with the effective investigation of matters of general public importance. And what you put into your version, you discarded that and you said,
sorry,
just stop interrupting, please. What you put in was...
Don't personalise this to me. This is the law of the land.
No, it was you.
Passed by the people.
You are the minister who introduced this bill.
Yes, I did.
And it says, what you said, instead of the law providing for the balance, you said it shall be for the house or houses concerned to determine the balance.
Final word to the Minister.
I said that because that was the entire rebalancing that a year's work of lawyers, of parliamentarians determined. And, 48 hours before the people are asked, or 36 hours before the people are asked, to come up with spurious arguments against it when we've spent a year looking at this is not fair to the people in this.
There's nothing
to try and frighten people with stazzy talk.
We've run out of time. Thank you both very much indeed. Thank you for coming in. Thank you, Miriam.
Well, last Thursday afternoon, in a blatant and shocking crime, a 29-year-old man